Okay, good morning, class. Good morning.
Good
Good
morning,
morning,
sir.
sir.
Yes, I've been finding it difficult to join. I think the meeting was actually we start. Yes, we last Tuesday we concluded our teaching on equitable interest and doctrine of notice. We look at the nature of equitable interest, and then we said that when you talk about equitable interest, they are divided into two. There are those that are modeled on common law rights and those that are invented by court of chancery independently. Those are the one equitable principle invented separately. And then we try to look at what are those rights that are modeled on common law principle, and we look at the beneficial interest in trust, so to say. And then we said that it allows uh, the beneficiary who had no any interest in a trust property to now be able to go after the trustee who has a legal interest. Then we look at those interests that were invented independently by equity, and we look at them such as equity of redemption, restrictive covenant, vendors equitable lien, and equitable mortgages generally. And then we also look at what we call temporal order, where you have competing legal interest between the same legal interest. We said that the qua pares tempore posto esture will be the order of the day, whose force in time is stronger in law. Then we look at the fact that there are instances where there could be modification of the temporary order. And a good example is where uh, there's a fraud or negligence or connivance to create a subsequent legal interest. We also talk about the fact that where other interest is postponed, when legal interest is postponed, the meaning is that equitable interest or whichever interest is created will take priority over and above a legal interest, notwithstanding the fact that we said, even to the whole world, a legal interest take priority over and above existing equitable interest. Then we also look at what are these equitable uh, equitable interests. We look at them one by one from what we call estate contract, restrictive covenants, mortgage or equity or redemption,
Yeah.
mortgage, equitable mortgage, as the case may be. Taufik Oweyemi, and please mute your speaker. And then Oluegbe, not Tika. I don't know which kind of this one is. So we look at all that. We also look at equity mortgage by looking at different method of creating equitable mortgage. We said that in nature where somebody own an equitable mortgage, I mean interest, you can only create equitable mortgage. We also look at an agreement to create a legal interest, which subsequently failed, maybe for non-compliance with the legal requirement of consent. It will not fail. It will rather be inchoate, incomplete, and then to give effect in equity. And so to say, then we look at equitable charge, and we say charge is where you are appropriating a debt to a particular property. Okay, it's not the whole, it's just part of it you are appropriated. Then we look at equitable lien, the right of unpaid purchase price. We look at that also as the case may be. Please hold on.
it ain't no Dewey Decimal System, but if I
Okay, sorry, I'm back. Sorry. We also try to look at doctrine of notices, and I said we have three type of notice. Notice. We said the first one is actual notice, where I explain the fact that actual notice where you have direct information about the encumbrances or an interest already created in respect of a particular piece of land. Then we talk about constructive notice, which you said that it is where equity will have presumed, especially where there's a legal interest. Your failure to conduct research, you will have discovered that the land is not free. It's a go back, so to say. And the last one is imputed notice. We say when you commission an agent or a solicitor to act on your behalf, and that agent having received information of actual or constructive notice and probably fail to disclose to you, you also deem to have received that notice. That notice is imputed on you. That's exactly what we were trying to explain. Okay, I think that's stop that. Just to do a recap. The last topic I'm supposed to teach you, I will be brief because we need to go slowly. My intention is to conclude next week, and hopefully, I think I should be able to do that. To conclude on Tuesday with you. The topic is on assignment of Joseph in action. Assignment of Joseph in action. Now, what do we mean by an assignment of Joseph in action? I'll go slowly. I have a meeting at. I'll try my best to say how I can cover. Now, when we talk about assignment of Joseph in action, what are we talking about? What is a Jose? A Jose is action. That's we can say the Jews, okay, in action. We are talking about Jews in action. Jews in action. Jews is in action. But a Jews in action is a personal right over property. Okay, so it's a personal right over property. But it can only be enforced by taking legal proceeding against such property, but not by taking physical possession. Okay, so that is a Jews in action. A Jews in action is a property right. Okay, we can only be enforced by taking legal proceeding, but not by taking physical proceeding. What do you mean by this? Property can be divided, is divided into two. I think you must have been taught, or probably you are aware of the fact that properties are divided into two. There's property can be classified into two. There's what we call realty or personality. Okay, we have realty and personality. Realty has to do with real property, which is fixed asset. Okay, and then you also have personality, which is your personal effect, personal property. So when we're talking about a Jose in action, we are referring to property rights, which we can only be enforced by taking legal proceeding. But it's not possible for you to take physical possession. In land, you can take physical possession. That's an example of what we're saying. Now, personality also is divided into two. It's not all personal property that you can take physical possession of. That's what I'm trying to let you know. The personal property can be divided into two. There's tangible assets and there's intangible assets. Okay, tangible assets and intangible assets. Now, a tangible property or a tangible asset is the property that can be physically possessed. You can physically possess them. Okay, that's what we call a tangible asset. Example: table, chair, car, your phone. Okay, your book. This can be physically possessed. Okay, now that is one aspect of property. I mean, personality property. Okay, so we said personality property can be divided into two. There's tangible and there's intangible. And I say tangible property is the one that you can physically possess. And I've given you an example of those tangible personal property, like a table, like a chair, like your phone, like your car. And I say these are all these ones that can be physically possessed, that you can hold of it. We can carry table together, we can hold a fan, we can hold a table, you can hold these are things you can physically possess. We call them choices in possession. Okay, choices in possession, not choices in action. We call them choices in possession, because they can be physically possessed. They can be stolen. A car can be stolen, your phone can be stolen, your chair can be stolen. These are tangible personality. Then we have intangible personality. Okay, we have intangible personality. What are the examples of intangible personality? We're talking about debt. Debt, when you owe somebody in Yoruba language, you can only owe that person. Is a right over that your debt. If you borrow somebody 20 million naira, he has taken the money. Or the acknowledgement of the fact that I owe you is the fact that you know he's owing you. You can't take physical possession of a debt. It's not possible. Copyright. Copyright is a right also. You cannot take physical possession of your copyright. You only see it when somebody infringes upon it. Okay? Shares in company. You can know that you have 100 of shares in the company, but you cannot also take physical possession of that company. Patience and design. You can also know that you have a patient and design over a particular property or brand, but you can also not also physically possess them. Okay, so these are examples of what we're talking about. When we said the personality can be divided into two, there's tangible, there's intangible. So intangible part of what we're talking about is what we refer to as choices in action. Okay, intangible part of personality is what we refer to as choices in action. So debt, copyright, shares in company, patent and design are your right over that particular process. You can only take legal proceeding to enforce them, but you can never take physical possession over them. So that is what we refer to as that's what we refer to. Ojewola Emmanuel Aderemi, you are disturbing the class. Ojewola Emmanuel Aderemi, you are disturbing the class. You open both your video, you are disturbing the class. So you have, as I was saying, I said, when you're talking about intangible assets, you are talking about those assets that you cannot physically possess. And I said, those ones are the one we refer to as choices in action. Those are the one we refer to as choices in action. Okay, we say there are choices in action. Now, having said that, from our teaching, I said to you, for everything that has is legal must always necessarily have its equitable part of it. Okay, anything that have legal must have must also have what we refer to as an equitable. Okay, now I don't know whether you people are able to, you are following me to the point that there's the difference between personality, tangible and intangible. I said, if you are following, let me hear from you. Are you following? Are you following?
Yes, sir.
Okay, you follow to the point that I'm able to explain to you what is meant by choices in possession and what is meant by choices in action. Okay, thank you. Now, we've been able to demarcate between tangible and intangible property, personal property. And I said, those ones that you cannot take physical possession, but you can only take legal proceedings to enforce it, are those that we refer to as choices in action. And we have been able to explain the example by talking about a debt, copyright, shares in company, patience and design. These are what we generally refer to as choices in action. Okay. Then choices in action can be divided into two. You can have a legal or equitable choice in action depending on the mode of creation. So you can have legal choice in action or equitable choice in action, as the case may be. What are the legal choice in action? These are the ones that actually created by statute. They are statutory in nature. You know, we said that equity follows law. Equity will not follow law where law is being used as an engine of fraud. Don't forget, we said that legislations, statutory provisions are law. Okay. Now, what is legal choice in action? There are such rights that can only be recovered under the law. There are those ones that you can recover those rights under the law. especially when we have the common law, okay, such as debt. Debt is a creation of common law. It wasn't created by equity. You have copyright, bill of exchange, policy of insurance, shares in company. You have laws that actually back some of this up. Okay, now those are the example of legal choices in action. Okay, they are generally debt, copyright, shares. They both fall into both categories. But to be, I mean, the honest about it is that the legal choices in action are those that primarily I just mentioned because they are created by statute. And I've been able to give you an example of some of them. I said debt, copyright, bill of what do you call it, exchange, policy of insurance, shares in company are good examples. What is equitable choice in action? They are right you also have that can only be enforced by proceeding in equity. Now, the legal choice in action are those who can enforce under the law. Okay, that is legal choice in action are those who can enforce under the law. Equitable choice in action are those that you can enforce or the right to enforce in equity. Okay, that's the difference between the two. And a good example is equitable interest or equitable choice in action is actually restricted to only trust fund or legacy in a will. Okay, so generally speaking, they are restricted to trust fund or legacy in a will. It's just talking about when somebody benefited from a will written by somebody. Now, but with the enactment of Judicature Act in 1873, 1874, 1875, when both systems were now merged together, what is the effect of this? Okay, what is the effect of both? This? That's what we are going to be looking at. So we can say that at common law, choose could not be assigned unless the debtor agree. One of the things about debt, we'll be using debt as an example because that is really critical. When we talk about a debt, we are talking about assignment of rights to collect debt from the other party. Okay, so you can assign your right to collect debt against the other party. Let me give an example. We have those people that call themselves, they help people to recover debt. Okay, when you owe some people money, they say they are debt collector. We have people like that. They call themselves debt collectors. Debt collectors cannot act on his own. Debt collector will only be acting based on instruction given to him by the assigner of that debt. Okay, so in law, under the legal assignment of choices in action, if I assign my right to somebody to collect a debt on my behalf, so that is what we call assignment of choices in action to recover debt on behalf of the assigner. Okay, that's what we are talking about. So you can also assign your insurance policy. You can assign your shares to to stock brokers. These are an assignment of what we are talking about. So, but at common law, at law, you cannot assign. If I have money to collect from Mr. A, okay, I'm the owner of my money. I have 20 million naira to collect from Mr. A. Under the common law, I cannot assign that money, I cannot assign that interest to collect that debt to Mr. B unless my debtor, Mr. C, agree to it. So my debtor must agree. There must be an agreement that, oh, Mr. C, the 20 million naira you owe me, I've assigned the interest to Mr. B to collect it from you. That is common law position. Okay, we are going to see what happened later after equity has intervened. So, and then that is only legal choice were recognized. There's nothing like equitable choice in action, except from the one I mentioned. Okay, so and then an equitable choice in action cannot even sue on his own name. Okay, so even where I've assigned interest to a third party to collect debt on my behalf, if it's an equitable, we'll see why it's an equitable. He cannot sue in his own name. My assignee cannot sue in his own name. He can only sue with my name. Okay? It's either he put my name first and put his name as second party. So it's not possible, whether as a co-plaintiff or as a co-defendant. So whoever is assigning, okay, you must put the name of the assigner because you don't have the right to sue. Okay? So these are the problems created by the common law. But with the emergence, with the merger of both systems, okay, it's not possible for you to be able to sue for the assignee to sue in his own name without necessarily joining the name of the assigner, provided that the debt is absolute. What do you mean by that? You cannot assign parts, okay, if somebody is owing you 50,000 naira, and you are now assigning your interest to another person to recover 20,000 out of it, that debt is not absolute. So in such a situation, you cannot sue with your name on your own. You still need to join the assigner, either as a co-defendant or as a co-plaintiff, as the case may be. So equitable assigning must always join assigner in action as either as a co-plaintiff or as a co-defendant, especially where the right of assignment is not absolute. It's not the entire debt. Okay, it's like somebody owe you 100 million naira, and you now assign the interest to collect that debt to several individuals. It's in parts. Okay, you assign it to Mr. A to collect 20 million out of it, another person to collect 10 million out of it, another person to collect 10 million. So it's not absolute. It's not the entire debt that has been assigned to one person. And as such, you cannot go directly to enforce that legal interest, that legal right against the debtor. You must join the name of the assigner as a party. That is what we are talking about. There's a popular case of Performing Rights Society, Performing Rights Society against London Theatres of Varieties. Okay, it's an interesting case you need to read. Performing Rights Society against London Theatre of Varieties. Okay, now that is all about that. I've just laid foundation. By now, we now understand the fact that assignment of chosen action those rights over property which can only be enforced by legal proceeding but not by taking physical possession. We have also seen the fact that property are divided into two, namely reality and personality. And then also we say that personality are also divided into two. We say tangible and intangible. And we say the tangible property can be physically possessed, like table, like chair. And we say intangible property cannot be physically possessed because they can only take place as action in chosen action. And those ones we refer to as chosen action. Debt, I said that to you. You can only know somebody who you can't take physical possession with debt. Copyright, shares in company. It is, and I also said to you, there are two types of legal chosen action. There's a legal chosen action, and there's also what we call an equitable chosen action. And we say, to be specific, generally principle of law is that legal chosen action are creation of statutes, are creation of law, and those are the ones that are, particular. Especially we are talking about debt, copyright, shares, they are legal chosen action. And then we said that primarily equitable chosen action is only restricted to trust fund and legacy under a will. Now, having said all that, which I believe you have understood, let's move forward to classification of assignment. Okay, what are the classification of assignment? I will try as much as possible to be brief because a topic you need to understand now, because every time people assign their interest to collect certain things that are chosen in action, people write a will whereby they now allow their ward to inherit their shares and stocks. It's an assignment, okay? But they will not assign it directly to those people, they will assign it to the executors. That is what we are saying. Equity has been able to remove all these bottlenecks before assignment cannot be done, okay? So we have, what are the classification of assignment? Now, the old common rule against assignment was, I say, was that finally removed by Judicature Act of 1873. I think you still remember Judicature Act of 1873 and then the Judicature Act of 1875, which actually merged both the common law principle and equitable principle together as one united legal system. Okay. Now, Section 25(6), Section 25(6) of the Act provides as follows. He said, any debt or legal thing in action, any debt or legal thing in action may be assigned at law. Okay, that's what law says. Any debt or any legal thing. So debt is really brought out as being particular, spectacular rather. And then say any legal thing in action. He's still talking about choosing action may be assigned at law. Now, the provision has been judicially noticed and they have been constructed to meet these four categories of assignment. Okay, number one is a legal statutory assignment of legal choices. Okay, legal assignment of legal choices, and it's just talking about legal assignment that are really stated in statute. Okay, there are statutory provision that allow you to assign. One a good example is this Judicature Act. Even under the PCL, that's Property and Conveyancing Law, and several other law, you have where an assignment of chosen action is statutory. Okay, your right to assign a debt, your right to assign this. So these are what number one. So legal statutory assignment of legal chosen action. So it's like you want to. There's a law that capture debts. Okay, there's a law that capture bill of exchange. The law that capture insurance and is statutory. These are what I'm talking about. And I said to you, anything that has to do with law, where you have a law about a particular issue, is legal. Okay, you cannot call it equitable. It's not equitable. Anything you see under the law is legal interest. Anything that law created is legal interest. Anything that's short of the provision of that law, where you cannot find anyone complying with that provision of the law, is going to take place in equity. It's just like when the law says obtain governor consent. Failure to obtain governor consent will render it null and void. That is still very clear to be legal interest. Your failure to do it is going to be equitable. It will rather take effect in equity, not for it to be discarded. Okay? Bolu Atife Olatoye, you are disturbing the class. Bolu Atife Olatoye, mute your speaker. Bolu Atife Olatoye, and there's another this name I don't even know. It's like a TikToker, note taker. Oluebu. Your speaker is on and is disturbing us. Okay? Now, having said that, the second one is legal statutory assignment of equitable choices. Okay, legal assignment of equitable choices. Okay, that is those one that also provided in the statute, but primarily what they are assigning is an equitable choices. I've given you an example of legal choices under the statute. You have trust fund. Okay, trust fund, when it's being assigned, whoever is taken as beneficiary is taken as an equitable interest. Okay, a good example is when a trust has been created. I think I mentioned that to you. Any beneficiary of any trust is an equitable. Okay, so because trustee is going to be the legal holder. So when you are benefiting from any trust fund or under a will, you are near an equitable. So you can also create that certain law, will law, for example, will act. You have will laws that actually create and give effect to some of these assignment of choices, equitable choices. Okay. Number three is what we call equitable assignment of legal choices. Equitable assignment of legal choices. What do we mean by that? Where you plan to actually assign under law, under legal. Okay? Your plan is just like an agreement to create a mortgage. Your interest is to create a legal assignment of choices in action, but unfortunately, you fail to comply with statutory provision. Okay, in law, it will be declared null and void because you did not comply with law. But equity will still take it as if that legal interest is still being created. Okay, let me come back. We're talking about equitable of legal choices, and I said it's talking about situation whereby you actually plan to create a legal choices in action, but you fail probably to give notice. You fail to put it in writing. We are going to be seeing those components now. Because for every legal choice in action, it must be in writing. Okay, so I want to assign my debts to you to collect on my behalf from Mr. C. I must put it in writing. That's a legal choice in action. Okay, but if I fail to now do so, it's going to be null and void under the legal interest, under the common law and under the law. Because that's what the law will say, just like section 22 of land use act, is a failure to obtain governor consent will render null and void. But inequity is not going to be null and void because you can actually sue for specific performance to just compare the other party to do whatever is needful. So if you try to create a legal choice in action and probably is in default, you are in default of some certain legal requirements, it will take effect as equitable choice in action rather than being void. And the last one is equitable assignment of equitable choices. These are just primarily equitable choices. Okay, equitable choices like trust fund, beneficiary in the trust fund, beneficiary under a will. These are particularly what we call equitable choices in action under that regard. Okay, now, but let me also tell you, number one and number two, legal assignment of legal choice in action, and number two are just statutory assignment. Okay, so we can say that from this classification, we just have two of them. We just have two of them. We have statutory assignment, which is legal, and we have statutory assignment, which is an equitable. That's number one. Both of them are legal. Okay. Then we also have an equitable assignment of a legal chose, meaning that we want to actually create a legal chose, but we fail, we're in default of certain things which ordinarily would have been null and void, but equity will still consider it to be a good choice in action. Number two is an equitable assignment of equitable choices. So if you look at those definitions, those classifications, they're just two. Is either you have a legal choice in action, which is statutory, or you have an equitable choice in action. Okay, so those are the two classifications generally. So let's start by looking at statutory assignment. What are the statutory assignment? What is the assignment? What is the requirement of statutory assignment of legal or equitable choice? I just show that to you now. What is compulsory that must be satisfied before you can create a debt? For example, let's continue to use debt. We say somebody owe you, so you want to assign your choice, your action to enforce a debt against naira, and you now want to assign it to Mr. B to recover that loan, that debt from Mr. C. Okay, what does law says about this requirement? How do you create that as assignment under the law? How do you create that assignment under the law? Number one is that every assignment that must comply with legal choice in action must be in writing. Okay, that's number one requirement. It must be in writing. That's number one. For every legal choice in action, it must be in writing. Now, that's exactly what I'm saying. If it's not in writing, what will happen? It will rather take effect as an equitable choice in action. If it's under the common law, the moment you don't put it in writing, you lose your right to recover that loan under assignment. To recover that debt under assignment, because it's going to be null and void. But with the intervention of equity and then the intervention of merger of equity and common law, it will rather take effect as an equitable choice in action. And that's what I've been trying to explain when I was talking about. So, assignment must be in writing, signed by the assignor. So when I'm giving you right to go and collect debt on my behalf, before your right to enforce that debt on my behalf, it must be in writing. That's number one requirement. You're going to be looking at them later. Number two, assignment must be absolute and not by way of charge only. Okay, assignment must be absolute and not by way of charge. Now, what do we mean by that? It must be absolute. We are going to look at that. When we say assignment by way of charge, it's talking about merely giving an assignee right to be paid out of the fund owed, not the entire money. Okay, you don't transfer the entire money. You are appropriating part of that money for the purpose of payment to the assignee. Usually, who is the assignee? Assignee in most cases are debtor. Okay, assignee in most cases are debtor. Let me just be frank with you. It only depends. It's only in certain category that you now have a third party. But in cases you want to really do it, if I'm assigning my interest to somebody, a third party, and I'm sending a note to that person to recover debt from you as an assignee, if you owe me 100 million naira, and I'm now saying, just give this person 20 million naira out of the money you owe me, that is not a requirement with legal justice in action. It must be absolute. Number one, it must be in writing. Number two, it must be absolute. So it can't be by charge that you just appropriate part of it. It must be entire debt. Jones and Humphrey will help you. Jones and Humphrey. And then in the case of Mercantile Bank against Evans will help you. So assignment must be absolute. It's not going to be part of it. Okay. Also, when you are assigning your rights under a mortgage, okay, the whole debt must be assigned to the mortgagee. That is it. When you are assigning your right, it's the whole debt that the mortgagee is entitled to, not part of it at all. Because you also have a assignment of that payment after you have paid. So what I was talking about is the fact that if by way of assignment in a mortgage transaction, okay, in an entire situation is the entire money that is being assigned. The entire money taken by the mortgagors was being assigned. And then there's going to be reassignment or repayment from the mortgagor to the mortgagee after you satisfy the debt. What I'm saying is that if I give you 50 million naira now, the mortgagor is going to assign the fact that in case is in default, okay, the mortgagee can take steps to recover the loan. Okay, so as at the time you are taking money from me, what you assign is the entire debt, not part of the debt. And when you also pay back, you're also free. You're also free from the entire money, because there's going to be a reassignment of payment after the whole money has been paid. You can read the case of Onashile against Idowu, Onashile against Idowu. And then we also talk about the fact that can the assignment of a part debt be done? Okay, assignment of part debt, because if it's part of the debt, it would also not qualify as an absolute. That's another thing you need to understand. Another cases you probably read, which I probably reported in my notes. Now, let me stand this warning. My notes is on this particular assignment is full of some typographical error. It's typo. So, I mean, if you read along that note with delay, okay? Because there are a lot of typo there where you're supposed to have a mortgage or you see mortgage. So read that. So what we're saying is that the assignment must be absolute, okay? And then to actually understand, for you to properly understand what we meant by that, I will commit the case of Western Nigeria Finance Corporation. Western Nigeria Finance Corporation against West Coast Builders. Very interesting case. This is where somebody owed 44,000. And they've already assigned their interest to a ministry that also owe them. Okay, the court has to decide whether it's valid legal assignment. Okay, it's only 25% of that money that they've assigned to defender to take from another ministry for Ministry of Works. Ministry of Works is also owing them, so they now decided to assign that 25% what the Ministry of Works is owing us, go and take it. And the court said, no, that's not a valid legal assignment of justice in action. That's Western Nigeria Finance Corporation against West Coast Builders, okay? Or West Nigeria Finance Corporation against West Coast Builder, you can read that. Also the case of Accra Perfumery against Thomas. Accra Perfumery Company Limited against Thomas. That one will also help you. Also the case of Udakasin Enterprises Limited, Udakasin Nigeria Enterprise Limited against Olisa. Okay, Udakasin Enterprises Limited against Olisa will also help you. For that case, actually explain what are the requirements. What are the requirements to be satisfied when we are talking about assignment of justice in action as related to part payment, part debt, as the case may be. Now, what is the effect of statutory assignment? Where the provision of the statute have been complied with, the assignment becomes the owner. Assignee rather becomes the owner. Now, in most cases, assignee, I said to you that in most cases, assignee may be a debtor, assignee may be a third party. It depends on the nature of the transaction and the way you frame your document. Okay, but usually for debtor, because if you send a note, you are likely going to send a note to the debtor. That's why the principal that and all. We are going to say the principal that and all. Like somebody asked a question one day, and he was trying to know what is that and all. And I was trying to explain to you that the principal that and all is talking about the day, the first notice to be received, not when the interest was created. Okay, so you have effect of statutory assignment is that whoever is assigned to, okay, becomes the owner of that trust at law. Whoever is assigned to, if he's assigned to a third party to go and take money from a debtor, he becomes the owner of that money. Okay, and he can sue the debtor without making the assignment a party. That is the effect of the statutory assignment and with intervention of equity. So you don't need to go back to common law principle whereby you must always join the name of assignor. Okay, so whoever has been assigned to, if I assign my interest to you and I say, Mr. C owe me 20 million naira, and I comply with the provision of statute, and I say, go and take the 20 million. So you've now become the owner of that money in equity. So, and you can sue Mr. C, who's owing that money, that money become yours, okay? And then another thing is that if it's not absolute, If it's not absolute, then it take effect as an equitable assignment. That's what you need to understand. And you don't need to also furnish any consideration. We are going to see that. I'm going to stop here because I want you to. I will start equitable assignments, which I believe hopefully I'll conclude on Tuesday. But let me stop here so that I can allow you to read through what we have discussed. And in case you have a question, let me take your question before I ask this, because I have another meeting to attend. Yes, questions? Question? And if there's no question, meaning that everything is understood, this class is very brilliant and it's good to teach brilliant students. Somebody want to ask a question? No question?
Yeah, good morning, sir.
Yes.
Not really a question. I just wanted to ask that, could you please repeat what you said on effect of legal or statutory assignment just now?
I just talk about the fact that the assignee of an interest become the owner at just at law. Okay, the money, if I ask you to recover debt on my behalf, you are the assignee, and then you have become the owner of that money. That's what I said. And you can go after the debtor by collecting that money without necessarily joining me. But I must have satisfied the requirement of statute. It must be in writing. The debt must be absolute. Those are what I said. I also talk about the fact that if it's not absolute, what will happen? It is not going to qualify and value under a legal assignment of chosen action. But I said to you that anything that fails to qualify as a legal chosen action will always qualify as an equitable chosen action. That's what I said. Do you understand? Do you understand?
Sir, thank you, sir.
Okay. Okay.
Yes, sir. Thank you, sir.
Sir, I have another question, sir.
Yes.
Yes, sir. Please, sir, can you shed more light on equitable statutory assignment of equitable assignment of equitable trusts in action?
What did you say?
Equitable assignment of equitable trusts.
Okay, well, I was talking about what we call classification, okay? And you are talking about equitable assignment of legal trusts in action. Is that what you want me to explain? Equitable assignment of legal trusts in action. Is that what you want me to explain?
Number 2, sir, not number 3, sir.
Oh,
I understand the equitable assignment.
I said that there are some assignments that are also equitable in nature. They are not known to common law, but they are backed up with statute. Okay, and I give an example: a trust fund, okay, or you benefit under a will. There's also statutory. Before you can benefit under a will, there are requirements under the will. There's a will laws. There's a trust act now. They are statutory. So the right to assign has also been stated in those laws. So though what you are assigning is an equitable interest, and I said to you that, for example, if you are a beneficiary under a trust fund, okay, whoever is appointed as a trustee, by now you should know that that person is a legal holder, while you are just an equitable interest. So there are certain particular trusts in action that are equitable in nature. Trust, beneficiary under a trust, beneficiary under a will, they are just equitable choices in action. But your right to take those assets are also equitable and they are chosen in action. So if somebody has written a will and he said, I hereby direct my executor, okay, to give 50 million naira to my children under this will. Now, what does law say before you can actually benefit as a beneficiary of that will? They must comply with the provision of the statute. What does statute say? Statute talking about the fact that after the will must have been read, you must obtain what they call probate. Okay, so there are statutory requirements before you can also assign your right under equitable choices in action. That's what I was trying to explain. I don't know whether you understand now.
Yes, I understand. Thank you so much, sir.
Thank you so much. Well, I have somewhere to go meeting, but I think we'll be able to do. We'll conclude this class on Tuesday by the grace of God. Somebody else will take over from Friday. Enjoy your weekend. Have a wonderful week. Bye-bye. Bye-bye.
Thank you, sir.
Okay, bye-bye.